Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa Iris Ewonia, and today I'll be taking you through leases, specifically covenants in land. Previously, I spoke about leases and I spoke about the nature, the types of leases we have, the features of a lease and all of that. So today we are going to talk about covenants, which in simple terms is an agreement in land that you can have in relation to leases. I made reference to the fact that leases are governed under Section 6 of the Land Act 2020 Act 1036. And that definition section for leases or leasehold interest stipulates that a lease is characterized with terms and conditions. So today we are going to talk about the terms and conditions that can be found in leases or landlord-tenant relationships. What is a covenant? A covenant in law is a solemn promise made by a party to a lease with the intention of being bound by it. In law, when we talk about promises, it is basically an assurance given by a person to another of their intention to be bound by something they have agreed on. So if I say that on this particular day, I am going to sell a book to you, I have made a promise to you, and I'm expecting that you give me reasonable consideration for the book I have sold to you when that particular day comes. So leases are characterized with covenants, which are the terms and conditions you find in the landlord and tenantship agreements. The technical meaning of covenant under common law is a written agreement under seal. There are many types of covenants that are found in law, but when we are talking about leases, we focus specifically on the four main types of covenants, which are either express covenants, implied covenants, usual covenants, or restrictive covenants. Express covenants are covenants which occurs where the party expressly states what covenants they wish to be bound by. So in the landlord-tenantship agreements that will exist or it will be drawn up by the parties will expressly state that on this particular day I will do this, or for this period that I am staying in this house, I will do this for you. So, for instance, in your landlord-tenantship agreement, we should know that you are supposed to pay rent at a particular time, or if not even a time, during a particular period when the month comes to an end. So these promises you make, the solemn promises you make in your landlord-tenantship agreement will be the express covenants. Implied covenants, on the other hand, are covenants which are implied either by the law, which is the common law, or by statute. So common law, pursuant to Article 11 of the 1992 Constitution of Ghana, is recognized as a source of law in Ghana. And by statute, we mean the Land Act 2020 Act 1036. And I will explain the particular provisions you can find these covenants under. We also have covenants known as usual covenant, which is a covenant where the lease is an equitable lease or an oral lease. Usual covenants are implied into the lease, and that was found in the case of Saki and Eshon. In our previous video, I stated that pursuant to Section 32 of Act 1036, leases or transfer of interest in land should be stated in writing. However, I stated that under certain circumstances, even when the parties have not reduced their agreement into writing, the courts will deduce that a lease has been created, and it will not be a contractual lease, but it will be an equitable lease. And the courts have a discretion to do this to prevent a party from suffering from what will otherwise be unjust or unfair if the leasehold agreement is not enforced by the court. So for such leases, usual covenants can be created under those. And we also have restrictive covenants. I explained what restrictive covenants are, and I differentiated restrictive covenants from easements. So I encourage you all to watch that video to get a comprehensive understanding of what restrictive covenants are. Because Section 6 of the Land Act 2020 Act 1036 states that leasehold interests have terms and conditions, some people tend to think that the conditions are only binding on the lessee because, after all, the owner had his own house or land, and it was you, the outsider, who decided to enter into an agreement to use the land for a particular period and pay rent. However, the lessor also has some express covenants to you, the lessee, that he must necessarily enforce. But we'll first talk about the lessee's express covenants he has in relation to the land. So the lessee's express covenants are usually as follows. He has a covenant to pay rent. Payment of rent is a necessary factor for leasehold interest. So if a person is claiming to be a tenant of another and the person is not paying rent, clearly there is no landlord-tenantship agreement between the parties. The lessee also has an express covenant against assignment, subletting, or parting with possession. He also has express covenant to repair the property when he necessarily causes damage or injury to the property. He has express covenant to insure, usually against fire, and also to use for residential purposes only. If the tenancy agreement states that you are only to live there and not to sell anything from that particular house or building or whatever you are staying in, then clearly there's an express covenant that you should use the house for residential purposes. So if you are to live there, you cannot go and sell tomatoes or pepper from the house because it is for residential, it's not for commercial purposes. The lessor, as I stated earlier, also has express covenants to the lessee. And these covenants are usually in the form of for quiet enjoyment, for repair of property, to insure the property, to pay rates and taxes, and to renew the tenancy. The case of Miracle and Tete speaks expeditiously about these covenants, so I encourage you all to read that case. The lessee, as I stated earlier, has a lot of implied covenants under the common law and by statute. So we are first going to talk about the implied covenant at common law, then we will delve into the implied covenant of the lessee and the statute. Under common law, the lessee's implied covenants are to pay rent, not to commit waste to the property, to pay rates and taxes, to permit the lessor to view the premises, to use for residential purposes only, to insure against fire, and to repair the property. It's important for you to understand that when they say the lessee must repair the property, it is only injury or damages that were caused to the property by the lessee or anyone acting under his authority that the lessee must necessarily repair. So if when you got into the house, a section of the house was already cracked or maybe it had been broken down, you, the tenant, you are not expected to fix that. It is the lessor's implied covenant to get it fixed or to repair it. But if you, in the course of you staying in the house, you cause the injury or damage to the house, it's expected that you will fix or you repair that injury you caused to the house. The lessee's implied covenants by statutes are as follows. The lessee has implied covenant to pay rent, to permit entry for repair to adjoining premises, against alterations and additions to the premises, not to injure walls or timbers, against assignments and subletting, against illegal or immoral users, against nuisance and annoyance, and to yield up the premises, lease, including additions in tenantable repair at the determination of the lease. The implied covenant of a lessee under statute is found in section 50 of the Land Act 2020 Act 1036. That particular section is so extensive. It talks about the lessor, the lessees, the sublessee, and assignees covenants in relation to the property. So I encourage you all to read that section for a comprehensive understanding of the covenants that a lessee must necessarily have in relation to the property he or she is staying on. The sublessee also has implied covenants by statute. In our previous video, I explained who a sublessee is and how that particular relationship can come out. I stated that, let's say, for instance, a person creates, maybe A creates an agreement with B, and in that agreement, A is leasing his property for a period of 50 years. B stayed on the property for 10 years. And during the 11th year, B entered an agreement with C and told C that C can stay in the property and pay rent for a period of 15 years. If you calculate the period of years within which B has stayed on the property and C, the new person, will stay on the property, that will amount to 25 years. And you'd realize that it is lesser than the period of years within which B is supposed to stay on that same property. So I stated that when such a situation arises, it creates a sublease in which a sublessee or a third party will come into the agreement the lessee has with the head lessor. I use the case of P.Y. Atta and Kinsman to explain what exactly a sublease is under the law. So I encourage you to read that case as well. And I also stated that subleases are recognized under Section 6 of Act 1036. With that being said, it's important for us to talk about the sublessee's implied covenants by statute, which is also found within Sections 50, 51, and 52 of the Land Act 2020 Act 1036. So the sublessee's implied covenants by statute are covenants for the future observance of the head lease and covenants to permit entry for repairs under the head lease. Typically, when the sublessee enters into an agreement with the lessee, who in relation to the sublessee will be his lessor, there is no contract that exists between the sublessee and the head lessor, the original owner of the property. So the law has identified that certain promises must be put in place to ensure that the sublessee will not forget who the original owner of the property is. So the sublessee must make sure to permit entry to the head lessor for him to repair the property and also the future observance of the head lease. The assignee also has covenants which are implied by statute, which is also found within Sections 50 to 52 of the Land Act 2020 Act 1036. In a previous video, I explained who assignee is, and I stated that an assignment can be created when a lessee, after spending some period of years within his leasehold agreement on the property, he grants the remainder of the years to a third party, and he expects that third party to pay the rent that he ordinarily would have to the head lessee. So with that being said, there are certain covenants that the law has recognized that an assignee must necessarily enforce, and they are implied by statute. And these covenants are covenant to pay rent for the future observance of the head lease and indemnity in favor of the assignor. Indemnity is basically when you as a person, you are supposed to be bound to do something, like you are liable to do something. But because of an agreement you've entered into with another person, you are not the one who is going to pay up or to repair any liability you have incurred. It will be the other person that is supposed to fix or to restore the person you breached the agreement in relation to back to the position he or she was before you breached your agreement. So all these are the covenants that an assignee must enforce. The lessor also has covenants implied under statute, which is also found within Sections 50 to 52 of Act 1036. The lessor's implied covenants under common law are covenants for quiet enjoyment of the property, obligation not to derogate from grant, and implied condition of safety of the property. So the lessor must necessarily ensure to enforce and to fulfill any promises he has entered into with his lessee in relation to the landlord-tenancy agreement. The lessor's implied covenants under statute, which I informed you earlier, are found within Sections 50 to 52 of the Land Act 2020 Act 1036, are the right to convey the property, quiet enjoyment of the property, freedom from encumbrances, and further assurance. So encumbrance is a charge or a security you place over a property in the event that if you fail to fulfill your obligations under the main agreement, you are not permitted to deal with the property you own until you fulfill your obligations under the agreement. So the lessor has implied covenants in the statute to ensure that the property he is leasing to another person is free from any of these encumbrances. It's not now that you've entered into an agreement that you are going to find that it's a mortgage property or whatnot. So the lessor must ensure that he fulfills this promise to the lessee. The sublessor also has implied covenants by statute, which are the validity of the head lease, past observance of the head lease, future observance of the head lease, and production of title documents and delivery of copies thereof. So if you enter into a sublease with someone, you must ensure that you fulfill these promises, or these promises are fulfilled to you. An assignor also has a covenant which is implied by statutes, which in this case is the Land Act 2020 Act 1036. And these covenants are the validity of the head lease, and past performance of the head lease. It is important for you to note and to understand that even though they have been implied by statutes, the parties can vary it as and when they want in their landlord-tenancy agreement. So even though the law expressly states in the statute that it's implied for you to do this, you can vary it, but it shouldn't deviate so far away from the law that it will clearly not be what the law has stated for you to do when you enter into such an agreement. I spoke about usual covenants, and I stated that these covenants are created in relation to equitable leases. So when an equitable lease is created, a lessee has usual covenants he is expected to necessarily enforce under the lease. These covenants are covenant to pay rent, to keep and deliver up the premises in the repair, to allow the lessor to enter and view the state of repairs, and to provide for re-entry by the lessor for a breach of a covenant to pay rent. So I stated that the payment of rent is a necessary factor you must enforce when you enter into a lease agreement. If you fail to pay your rent, you cannot use people or things to block the lessor from re-entering his property to enforce the breach of your agreement or your covenant to pay your rent. So you, the lessee, you must ensure to enforce and to abide by these promises you have made in your agreement under the leasehold agreement. The lessor also has usual covenants in relation to the land, and that is a covenant for quiet enjoyment. The case of Flexman and Corbett stated that other covenants may be usual in the particular circumstances of a lease, having regard to the locality or the nature of the business or trade. Questions of fact in relation to the quiet enjoyment of the property will be decided on case-by-case basis. So what is stated in this particular case may be different from the other case. When the parties agree that they want to review the payment of rent, it must be expressly stated in their landlord-tenancy agreement. And that was stated in the case of Da Costa versus Ofori Transport Limited. I encourage you all to read that case for a comprehensive understanding of what rent and its related matters are in relation to leases. The tenant's duty to pay rent is unaffected by fire to premises unless expressly stated in the agreement. And that's in the case of Idrisu versus Attorney General. So in that case, it was stated that even if the house you are staying in it burns down, it does not mean that you are not supposed to pay rent. I encourage you all to read that case for a comprehensive understanding of renting. But it's important for you to understand that the payment of rent doesn't necessarily mean that you must give money. In the case of Adomako versus Enterprise Insurance Company Limited, it was stated that you can pay rent in the form of transferring of shares you have in a property or in a company to another person. As I stated earlier, the lessor has a covenant to pay rates, taxes, and utilities. So this is a usual duty that's expected of your landlord. But sometimes a tenant can take up this duty under certain specific circumstances. Utility which is consumed on the premises is usually the duty of the lessee. So if you're a tenant in a house and you are incurring any utility bills from using your lights or your water, it's not your landlord that necessarily is expected to pay up these bills. It is you, the lessee or the tenant, who is expected to pay the bills. The lessee also has a covenant to ensure that he doesn't assign or sublet the property without the consent of the landlord. You must always seek the consent of your landlord before you decide to transfer the interest or the duration you have in the property to another person. It doesn't matter whether it's a sublease or an assignment. You must inform your landlord, and the landlord must give you that consent. But the landlord must ensure that he does not unduly and unreasonably withhold that consent. No payment must be exacted for the consent. You don't have to give any money. But it may also lead to the forfeiture of your lease, which will be explained later in a next video. And that was also in the case of Shandov and Zaini. The lessee also has a covenant against nuisance. A nuisance is anything that interferes with the quiet enjoyment of your property. It prevents you from enjoying the property you own or you are staying in. And it is determined by case basis. It's a question of facts. So there's not really a particular definition, or there's not really any statute that defines what a nuisance is. It is the situation at hand that will determine whether the particular instance amounts to a nuisance. So the covenant against nuisance must be enforced by the lessee. And that was in the case of Edu and Eche. The landlord also has a right to convey his own property. It's because the landlord typically owns his property, so he has a right and capacity to convey it to another person. However, he must ensure that if someone is already living on the land, he must necessarily inform that person of his intentions to convey that property to another person. There are, however, reliefs for the breach of your promises or your covenant in relation to the property, and that will be explained later in our next video. As I stated earlier, the lessee has a right to be placed in quiet enjoyment of the property. The lessee also has a right to be in exclusive possession of the property, and it guarantees against all lawful forms of entry from the landlord or any other person claiming through the landlord. So if you are a tenant in the house and the landlord wants to enter the house, you have the covenant or quiet enjoyment of the property. So the landlord cannot enter under certain circumstances, but the law recognizes that when it becomes necessary for the landlord to enter, maybe to repair the property, you must grant the landlord the free entry to enter the premises to fix up any injury or damages that were incurred on the property. It does not also cover unlawful acts of entry by the landlord, as the tenant has a right to enforce his right in court. As common law, the covenant or quiet enjoyment comes to an end with the interest of the lessor. But if it is an express covenant or is implied by statute, it goes with the reversion. So when the property, reversion in this case means that when you have exhausted the period within which you are supposed to use the property under your landlord tenancy agreement, the property goes back to the landlord. So if the covenant is implied by statute, which in this case it will be the Land Act 2020 Act 1036, this particular covenant will go with the reversionary interest to the landlord. As I stated earlier, the landlord has a covenant to ensure that the property is free from encumbrances. The landlord must assure the tenant that the property is not encumbered in any way, either by an easement, a license, a profit, or a mortgage. Thus, if there is any encumbrance on the property, the landlord must make it known to the tenant for the tenant to decide whether he or she wants to take the property with the encumbrance or not. So if you are going to rent a place, the landlord must inform you if the particular property you want to rent is a mortgage property. It is not when you are in the house that you will be forced to move out of the house because maybe it was mortgaged and the time is up and the person failed to pay up his duties under his agreement. So landlords, you must ensure to inform your tenants of any encumbrance that is placed on the property. The landlord also has a covenant to execute and do all lawful acts to further or more perfectly assure the lease properties to the lessee. All this must be at the expense of the lessee. Examples of the acts in which I'm referring to are properly signing a defective document or stamping or registering any document. So landlord tenancy agreements under sections 32 to 36 of the Land Act, they must be in writing and they must be signed by the parties in that agreement. So the landlord must ensure that the property, the agreement is reduced into writing and that he has signed it. And where he must stamp it, he must also ensure that it is stamped. But the expenses that will be incurred in relation to the property must be borne by the lessee. There's also a covenant to repair, and sometimes it is the landlord who must repair the property or the tenant who repair the property. And that was seen in the case of Saki and Eshon. So I encourage you to read that case for a comprehensive understanding. However, covenant to repair could either be to put the property in repairs, or to keep it in repair, or to leave it in repair. All of these, you must necessarily ensure that you fix up any injured walls or damages that have been incurred on the property. When you want to enforce any covenant under the agreement, the lessor and the lessee must remember that they have a privity of contracts when it's in relation to express covenants only between them. And they must also remember that there's privity of estate, whether it is express, implied, or usual covenants. For privity of contracts, the lessee must be liable for a breach even though he has assigned his interest to another person. But this is under certain circumstances. As I stated earlier, when it comes to assignments, the lessee transfers the remainder of his interest to a third party. And ordinarily, you expect that if any damage occurs after he has transferred the remainder of his interest, he's not the one that's supposed to be called to fix that damage or the injury that has been incurred. However, the law recognizes that under certain circumstances, the lessee can be liable for any breach that will occur, even though he has transferred the remainder of his interest to a third party. It is important for you to understand that between the lessor and the sublessee, there is no privity of contract or privity of estate. However, the sublessee may take the benefit of or be bound by a restrictive covenant depending on the circumstances. However, in relation to lessor and assignee, there is this privity of estate but no privity of contract. The lessee is still liable to lessor under privity of contract. It is thus advisable for the lessee to seek indemnity from the assignee. Thank you for joining us in this wonderful session on covenants in relation to leases. By way of a recap, I stated that covenants are solemn promises that a person makes to another person with the intention to be bound by it. And I stated that leasehold interests are characterized with terms and conditions, which in this case will be the covenants that must be enforced. I gave types of covenants and I spoke about express, implied, usual, and restrictive covenants. And I gave the necessary examples of covenants that must be enforced by any kind of person that is captured under a landlord-tenancy agreement. Thank you for joining us. Do not forget to like, comment, subscribe, and share our videos to your friends and your peers for them to understand what they are entering into when they decide to sign a landlord-tenancy agreement, and for them to know the necessary conditions they will be bound by under that agreement.